Let's move on to the case that we're going to talk about today, which is Kelsey Fitzsimmons. Now, I'm just getting into this case now. Apparently, this case has been going on for a little bit, a couple months already, but I'm getting news of it now.
So, I bet you thought we went out the back door.
We had faith.
Yeah. Come on over here, guys. So, thanks for sticking around. First of all, I wanted to introduce Martha Coakley, who brings such a wealth of experience to this case.
Kelsey and her family have agreed to all of the conditions that the court has imposed. She looks very much forward to going home to recover, to prepare for what's ahead in this case, because she is innocent, and we believe that, and she knows that. And she looks forward to that recovery and her day in court.
She doesn't belong in jail. We want to fight this case from the street. We also have to focus on Kelsey being reunited with her baby and get into probate court a few doors down here. So we have a lot on the plate, but for now we just want to get Kelsey home. Kelsey has a great family. I always feel like I'm halfway down the field in court when I have a great family sitting behind me in the front row, ready to do whatever they can do. The family here has gone to extraordinary lengths to make sure that they can show the court that Kelsey is safe and protected and is where she needs to be.
Yeah, I'll just add, look, this young woman has faced a lot in becoming an officer of the court, a police officer. She's faced a lot since that day. She is committed to her family and friends, and she is committed to listening to the court and doing what she needs to do to get back on track. But in the end, we believe that when we have that day in court, she will be innocent, and so we look forward to that day.
Kelsey, want to say anything about just how it feels?
What do you think, Kelsey?
The truth will come out.
Thank you. We want to get her home and relaxed.
Kelsey Fitzsimmons was out on bail. She was under house arrest. She had a GPS ankle monitoring device. But part of the restrictions is that she was required to blow into the scram device multiple times during the day to test for her alcohol. This was very difficult for her to do because, after all, she was shot. In case I didn't make that clear yet. So she has broken ribs and all types of other injuries that she's recovering from after spending about 53 days in the hospital. Her attorney, Tim Bradle, filed a motion with the judge to simply modify the restrictions. Let's not make this so torturous for a presumed innocent individual. Let's make this a little bit more easy and allow her to test some other way. We'll do a urine test, do some other alternative ways to test. So that was the motion. And the judge decided that since it's so torturous for Kelsey to use the scram device, well, we'll just lock her up and that will be less torturous for her. Apparently that was the thinking there. So Timothy Bredel filed a motion for reconsideration and a supplemental filing with a medical note from the treating surgeon who treated Kelsey at Mass General Hospital, showing in that letter what her conditions were, what her injuries were, and that it's very likely that she is still suffering from broken ribs and difficulty breathing into these type of devices. Well, the judge came out with an order yesterday saying, too bad, I'm not reconsidering the motion and Kelsey can sit in jail. As you know, on this channel, I try my hardest not to use profanity. But I got to tell you, this judge is really, really testing me.
The attached email was purportedly sent by Assistant Chief Probation Officer Jeff January at 6:21 p.m. on September 10th, 2025, the day before the hearing on Fitzsimmons' emergency motion for immediate relief from scram order. Purportedly sent. If you have kids in your car or in your room, or you have me on a public television, please take me off, put on your earbuds. Jeff January was in the fucking courtroom. And he got up and he swore to tell the truth. And he testified and we heard him. Purportedly sent by? I see how this is going to go. Armchair detectives, do your thing because there is something going on here. And you know how I say Massachusetts is where your constitutional rights go to die? They're dead. It's just too late. They're dead.
Also, some parts of this order, quite frankly, reads like a dumped girlfriend. I mean, it's just like she needs a bowl of ice cream immediately. That's what this judge needs, not an opinion in an order on a criminal case. As we're going to see, we're going to pull up something from Melanie Little because she does have some of these documents. So if you're sharing it with Melanie, share it with me too. Share the wealth so we can all get our heads around this, have more eyes on it, and some more legal analysis that we can do. So let's just give a little bit of a background in case you're new to the case, Kelsey Fitzsimmons, what happened in her case. Kelsey Fitzsimmons is a North Andover police officer, and she went through a postpartum depression, and she was having trouble mentally with her mental health. At some point, she had her gun taken away, put on leave, and then sometime later, she did have some sort of fiance, and she was at some sort of bachelor party. As the allegations go, they got into some sort of disagreement, or argument where she said something about perhaps she's going to hurt the baby. Okay, so the fiance went and got a restraining order, and then at some point there was some sort of altercation at her house. And the question is, so these are police officers. So she's a police officer, and then some of these other police officers responded to her house, and they came in and they basically said, okay, we have to take away your child. Obviously, very traumatic for the mother, for Kelsey. This is where the question is, what happened? So according to Kelsey, what happened is that she held a gun to her head, and she was not very stable. She was you're going to take away my child. Well, guess what? I'm going to shoot myself. Okay, so that was what she claims happened. And according to the police, what happened is that, no, she pointed her gun at them. And one of the police officers there shot her. And she actually made a recovery. So she was shot in the chest. She's in the hospital for many, many, many days. As you can imagine, it's not so easy to recuperate from being shot by a bullet. She was arraigned in her hospital bed. And now the question is she going to get bond? Now, what was very interesting in this case is that the grand jury did not even indict her on attempted murder. If you believe the police officers in this case, where she actually was trying to shoot them, and they responded in self-defense by shooting her, well, isn't that attempted murder? But the grand jury did not indict her on attempted murder. Instead, they indicted her on assault with a dangerous weapon. Okay, it's still not a light offense, but nothing like attempted murder. She was being held. She did not have bail granted right away. And then eventually, after some hearings, she was granted bail with certain conditions. Like all bail is, she has certain conditions. One of them is house arrest. And one of them was that she had to test with a scram device. Even if your offense doesn't necessarily have to do with alcohol, that's one of the requirements. Sorry, you're locked up, you're charged with something serious. You just can't go drinking now and having too much of a good time. So whether it's drug testing and alcohol testing, this is very common in restrictions when you're released on bail. You have to test. Now, there's a number of different ways to test. Now, apparently in Massachusetts, they have this way called scram. And scram is that you can breathe into this machine, which records at the police station. She's also on house arrest. Tim Bradel, who's phenomenal, he also filed that she couldn't have a GPS monitor on her leg. She didn't want to have this ankle bracelet because she needed to go for some surgery. He didn't think that they're going to do the surgery with her ankle monitor on. So he wanted that removed. All right, so he did file a motion for that. They had a hearing, and the judge denied it because he didn't submit any medical evidence showing that the ankle bracelet has to be removed. Then he filed this other motion, which is to not require her to test with a scram device. Why? Because she was just shot with a bullet, and she's trying to recover, and she has broken ribs, and who knows what else going on in her body, and it's very difficult to breathe into this scram device. You have to breathe with a certain strength for a certain amount of time, and it's very difficult for her to do. So he's saying, hey, no problem testing. Yeah, completely good. We'll test, but we just can't use the scram device. We got to figure out some other way so that she's not in tremendous amount of pain while she's trying to test with the scram device. So again, the motion is just modify her release restrictions. As soon as I heard the initial give and take between the judge and Tim Bradel, I was like, oh, this is not going well. Like, this is not going to go well. I just don't like her tone. Right away, something was not going to go well with this. You can just kind of feel her attitude a little bit right from the beginning.
Okay, so you're asking the court to adjust the court's order that's been in effect for 3 days with no medical evidence to support your claim that she cannot do it.
Well, I think you have 2 affidavits and the email from probation. I think that's pretty persuasive evidence that this is extremely difficult.
The email from probation is not evidence. If you have any evidence, now is your opportunity to submit it.
I don't understand the court's position. That's not evidence.
Okay, it's an email. It's hearsay. Commonwealth, do you have a position as to the submissions of an email as evidence in this hearing to relieve the defendant, Ms. Fitzsimmons, of a condition that's been in effect for 3 days?
I don't know why that's annoying the judge. I think just the opposite. if you have a condition that's in place for 2 weeks, 3 weeks, 2 months, and then all of a sudden you come back to the judge and say, Judge, this condition is too hard for us. Well, what happened the past 2 months? Past 2 months you're able to do it. How come, all of a sudden things changed? I can understand maybe a little bit attitude that way. But here we have, this makes a lot of sense, right? You have this condition of release. We're trying to do it, and we can't do it. She can't do it. The tone that you're getting from the judge is that she's upset that you're coming back to me after 3 days. Well, yeah, because we can't do it. That's why we're bringing this up immediately in front of the judge so that there's no argument that, you did it for the past 2 weeks. Why bring it up now? What she says here is that, well, what did you submit? You're claiming that she has some sort of medical condition that it's very difficult for her to perform the scram test. Well, what type of evidence do you have? And Tim Bradel says, well, we have affidavits and we also have an email from the probation officer. So here you have the probation officer who's really on the side. There's no pushback from the probation officer. And in fact, a lot of this hearing, he's actually giving testimony. And he's saying that he actually saw Kelsey's difficulty of doing the scram test. The judge right away says, well, an email is hearsay. Email's not evidence, right? So that's not evidence. And by the way, affidavits aren't even evidence either. If you want to speak about technical rules of evidence, affidavits is like the easiest form of hearsay. So she's basically, the judge is saying, well, there's no evidence. You're not submitting any real admissible evidence into this hearing.
I don't want to put anybody on the spot, but we have the person who sent that email here.
Okay.
So there is an email from the probation officer who's actually in court to testify about what he saw and what's going on with the testing, because she's trying this testing and sometimes the testing is not even working. He says that what happened here is that there were some days, let's say she's supposed to test September 10th, she's supposed to test, and it registers as an incomplete test. So she tried to test. It was too painful for her. So she couldn't do it, but it registered as incomplete. Eventually, she actually performed the test, even though it was extremely painful for her, but she did it. Now, there are many cases where you miss testing completely. The defendant just misses testing. He doesn't do it either purposely because he's drinking or for some other reasons. But this is a case where the probation officer said on the stand, they wouldn't consider this as not testing. They wouldn't consider this as non-compliance. She is compliant. It's just that she can't get the breath out in the first attempt before she kills herself to do it. So it's hard for her to summon up the courage to actually do this. Let's listen a little bit further.
You have a burden, it's your motion. What do you want to do?
Well, Judge, I don't think that
So again, I don't know what that question was either. So the judge turns to Tim Bradel and says, all right, this is your motion, your burden. What do you want to do? What do I want to do? It's in my motion, number one. Number two is I just said what I want you to do. I just said that we've got affidavits here, we've got emails, and therefore, because of that, you should take this, that we're not just making this up. We have affidavits, we have emails from the probation officer who is more than happy. He's here to testify that, yes, she's having a lot of trouble doing this. So what do I want? Exactly what my motion says. I want for you to modify the conditions of release.
Is the court saying that papers and emails and affidavits are not sufficient?
This is an email from a probation officer. The court gives that 0 weight.
Yeah, the court gives that 0 weight. An email from a probation officer, the court gives that 0 weight. Technically, in rules of evidence, she's right. In rules of evidence, if this was a trial, then she's right. She should give it 0 weight because it's hearsay. It's not evidence. But we'll see in a minute if that matters.
Well, then you have an affidavit from Ms. Fitzsimmons and you have an affidavit from her mother of the physical observations of what happens. I think that's more persuasive evidence than a doctor saying something to the effect of, I think it's self-evident and it's common knowledge that if you have broken ribs, that it's hard to breathe.
What evidence do I have that she has current broken ribs and that she's suffering from broken ribs at this time?
Well, you have an affidavit from her mother. You have an affidavit from Ms. Fitzsimmons. Over here, I submitted the instructions from Mass General about broken ribs.
Okay.
I mean, I just would argue that it's somewhat self-evident as well.
And so he's saying, well, I did actually submit the instructions from Mass General. So there's a hospital, Mass General Hospital, where she was admitted to. And yes, he didn't get all the medical records apparently from Mass General Hospital, which is probably voluminous because she was there for like 53 days or something, having all these type of surgeries. And she was shot. Did you not get that part? She was actually shot. I just want to show you just one part of this. What does the statute actually say? Like, we always like to ask the question on this channel, what does the law say? Like, shouldn't we look at the law, see what the law says? So let's take a look at the law. This is from the statute that the judge actually quotes in her opinion. The rules concerning admissibility of evidence in criminal trials shall not apply to the presentation and consideration of information at the hearing, and the judge shall consider hearsay contained in a police report or the statement of an alleged victim or witness. So here you have like straight out in the statute itself where it says that, no, we don't go by the rules of evidence. That's not this isn't a trial. You can even accept hearsay statements. Everybody knows about hearsay, and that's still admissible in this type of hearing. Yes, this is not a trial. You got that right, Judge. This is not a trial. You're right, 100%.
Attorney Bradel, here, first of all, I do have a question. So Ms. Fitzsimmons is able to do the scram, is that correct? Or is she not able to do it? I don't know. Is she not able to do it?
I think, that depends on whether the court is willing to tolerate that material represented in the
The court
affidavit.
is not tolerating anything. Okay, let's be clear. I'm not tolerating anything. The court is not tolerating anything. Ms. Fitzsimmons is a defendant. In lieu of incarceration, my order was that she submit to scram. If she cannot do that, I need to know that. Can she do that or not?
She can do it
Okay,
under the terms that are
So-
laid out in the affidavit
so you're saying she can do it on her own terms?
with significant pain.
No, that's not what he was saying. He wasn't saying that, you can do it on your terms. Oh, is that what you're telling me? You're telling me that you can only do it on your terms? Yeah, I'm the judge here. No, that's not what he was saying. He was saying that she can do it if you want to put her through hell. That's what if you want to do that, she'll do it. Like, she can do it, but that's what's going to happen. She's going to be put through cruel and unusual punishment. It's going to be very difficult. It's going to be very painful for her.
And dizziness and having to recover for several hours.
I understand what you're saying. It's certainly not the court's intention. It's not the court's position to have Ms. Fitzsimmons in any pain at all. So I appreciate your argument. Do you have anything else to add?
I would suggest, Judge, that I think there's other ways to do this. If the court wishes to have her tested for alcohol compliance, lack of alcohol, that's completely fine with the defense. But just the means that's being employed is kind of a torture device for her.
Okay.
And so we object on due process grounds to that.
Oh, okay.
But
It is not this court's intention
I understand.
to torture Ms. Fitzsimmons at all. The court's goal is to make sure the community is safe and Officer Noonan is safe. So I hear you loud and clear that the defense views Ms. Fitzsimmons having to do the scram as cruel and unusual and torture. Is that your position?
Well, that's an Eighth Amendment position. I suppose that can be put in there as well. But Judge, I think that, that there's
And Officer Noonan is the officer who, according to their story, she pointed the gun at.
probably other alternatives that she could do that I believe are out there. But I know that might step on the court's other order for house arrest, that she would have to go to a facility. I know there's like urine tests and other things like that. So I know there's other possibilities out there that, again, she's not trying to use this to create a situation where she can go.
By the way, this whole idea that Officer Noonan and the community have to be protected from her. By the way, do you ever see this officer, Kelsey? I wouldn't be scared of her. With respect to Officer Noonan, again, just remember, she was shot. She's recovering from being shot. She can barely breathe into this machine. What do you think she's going to do? She can't physically probably pull the trigger of a gun. She probably can't physically hurt anybody if she tried in her state right now, even if she would go completely crazy. I don't think she'd be able to harm anybody in her state right now. So a lot of this talk about how we have to protect the community and protect Officer Noonan because this person who just went through 53 days in the hospital and multiple surgeries and has broken ribs, who knows what she's capable of at 5'3". It's just a little much. I can't force her. I don't want to put her through. This is the judge. The judge says I don't want to put her through cruel and unusual punishment. That's that Eighth Amendment. We're not allowed to do that. Cruel and unusual punishment. So since she cannot comply, even though Bradel said she will comply, it's going to be very difficult for her. So you got to figure out what your argument is. Is it that she's not going to comply? And this is what she said. She said she's not going to comply because it's very, very painful for her. And therefore, she's not going to comply. But there's no evidence of that. She did comply. She complied. That she even tried and was incomplete at certain times, but she eventually got it. And then she was dizzy and in pain for the rest of the day. But that's what she said. She said that she's not going to comply. And since she's not going to comply with the restrictions of her release, well, then I'm revoking her bail and she has to go be locked up again. That's what happened. And that's what's a little bit sickening here. The motion was just to remove this restriction, remove this scram. And if the judge doesn't want to do it and he's saying, look, we will comply, it's going to be very difficult for her, but she'll comply, then the most that you should do as the judge, say, I'm sorry, we're not releasing that restriction. So either she complies. If she doesn't comply, then we're going to have her warrant out and we're going to arrest her. So she better comply. And good luck. I mean, that's what she could have done. But instead, she said, no, she can't comply because even though you said that she is going to comply, even though it'll put her in pain, but she's going to comply. But that means that she's not going to comply. And therefore, we have to lock her up. So that's what happened here. The motion for relief filed without any medical support. And again, this without any medical support is just like, Okay. She was shot. Did I forget to mention that? Like, is anybody disputing that? Just 2 days after the second hearing, appears that Ms. Fitzsimmons has been only sporadically able to blow into the device to the extent necessary to show a result. The court notes that defense counsel never advanced, and listen to this part, the court notes that the defense counsel never advanced any argument during the 2 prior hearings relative to any physical limitations that would interfere with Fitzsimmons' ability to abide by the conditions of release. So this is the prior hearings. So this is, she's saying, well, the judge saying, well, you never said that you wouldn't be able to comply with scram. So how are we supposed to know? Well, why didn't you bring it up then, right? This is always a point that the judge like to do. Why are you waiting? What, you should have brought this up when we were talking about it initially. Well, here's the reason. The reason is that we didn't know. She never tried it. How are we supposed to know what this testing is like if she doesn't try it? She just started trying it, and that's the problem. Fitzsimmons has moved twice. Like, oh, wow, twice. That's a lot. In a 3-day time frame to amend her conditions of release. Twice. Remember, the first time was because she wanted the GPS removed so she can have surgery. You're just filing stuff. Twice you've moved to amend the conditions of her release. Twice. Yeah, because she wanted to have surgery because she was shot. Did I forget to mention that? So she has to go. We were nervous that the GPS is going to interfere with her surgery that she needs. Does the court have a problem with that? On neither occasions has she submitted any medical evidence to support her claims. Remember, the first time when she filed to remove the GPS, they didn't attach any medical record saying that they can't do the surgery if the GPS ankle monitor is on her. So therefore, the judge denied that also. The imposition of conditions is the court's order after careful consideration of the evidence to fashion the least restrictive conditions that will reasonably assure the appearance of the defendant and the safety of all other persons in the community. Just days ago, the court concluded that the condition of remaining alcohol-free and submitting to scram monitoring was necessary. It was necessary to ensure the safety of the community. We have to protect the community from Kelsey. After a thorough review of all the arguments and submissions by the Commonwealth and Fitzsimmons, that the conclusion remains unchanged, regardless of Fitzsimmons' claimed physical limitations. Just because you had 3 people who witnessed it, that's just claimed physical limitations because, after all, you didn't actually show me a medical record that she was shot. Did I not mention that yet? Based on an affidavit submitted by Fitzsimmons' mother, the testimony of Assistant Chief Probation Officer Jeff January about his observations of Fitzsimmons' apparent pain during the scram installation, and the representations of Fitzsimmons' counsel that it would be cruel and unusual punishment and torture to continue to require Fitzsimmons to comply with the conditions of being monitored by scram, the court concludes that Fitzsimmons cannot abide by the condition of being monitored by scram. Did you follow that? The court concludes that Fitzsimmons cannot abide by the conditions. Did anybody say that she can't do it? Everyone said that she could do it. It's just very painful. And that's what we're asking you to modify it and take away that part. Nobody said that she cannot do it. No one said that she's not going to comply. Nobody said that. You just made that up. Without this condition, which ensures that she does not consume any alcohol, the court cannot assure the safety of Officer Noonan. Why don't you call Officer Noonan? You know what? Call Officer Noonan into this hearing. Say, Officer Noonan, are you scared of Kelsey? Are you scared that she's going to do something to you? And all other persons in the community, of course, all the other persons in the community. We have to protect the community from Kelsey. Okay, and then look at this footnote, which we always enjoy the footnotes. It says, while the defense counsel suggested that there are alternative methods to scram for ensuring that Fitzsimmons remains alcohol-free, he failed to present any specific viable alternatives for the court to consider. Well, he did. He said urine. So all you have to do is say, okay, we will modify the order that she's on house arrest, and we'll say she has to be on house arrest for 23 hours a day, and for 30 minutes she's able to go and drop off her urine sample. You could do that, right? I mean, that's not crazy. So that was the opinion there. So, and it's heartbreaking. Now she's locked up. She's going through a lot. And again, everyone has the presumption of innocence. And what actually happened in the apartment? I don't know. I don't know what actually happened. Did she hold the gun to her head? Did she hold the gun at the officer? Was she having a mental breakdown? I don't know any of that. I don't know nothing about that. And I'm not going to give an opinion about it. But what happened in the hearing today, I think, was just not right. It's just not right.
Purportedly sent.
So you're saying she can do it on her own terms?
Jeff January was in the fucking courtroom. And he got up and he swore to tell the truth. And he testified and we heard him.
He wasn't saying that, you can do it on your terms. Oh, is that what you're telling me?
Purportedly sent by?
You're telling me that you can only do it on your terms? Yeah, I'm the judge here.
I see how this is going to go.
That's not what he was saying. He was saying that she can do it.
Armchair detective, do your thing because there is something going on here.
But she's going to be put through cruel and unusual punishment. So that's going to be it for today. Glad to be back. Hopefully next week we'll have many more videos as well. Enjoy the weekend, everybody. If you haven't yet, please subscribe and like. If you want, see you next time.